If you would like to learn more about any of the topics discussed on this webinar, or if you require advice on any other business matter, please do get in touch with the AKEPB. We are here to guide, help, and support you on a confidential one-to-one basis. We could also assign you a business mentor in your sector or put you in touch with professional advisors should that be required. Get in touch by emailing akepb@iiuk.org or by contacting a member of the AKEPB whose details can be found in the institutional directory.
We are very fortunate and grateful to have with us today three distinguished speakers. Ian Robert is the head of business recovery and an insolvency partner at Moore Kingston Smith, a leading UK firm of accountants and business advisors. Ian is a licensed insolvency practitioner with over 25 years of experience of corporate recovery. Richard Rendell is the CEO of Rendell & Co., a boutique firm of licensed insolvency practitioners and chartered accountants with many years of experience in business recovery, turnaround, and insolvency. Richard was previously a senior partner at Baker Tilly before setting up his own firm. Ambuja Bose is a partner in the commercial litigation team at VWV, a leading full-service law firm. She advises insolvency practitioners, creditors, shareholders, and directors of distressed businesses on all aspects of contentious and non-contentious business debt recovery and insolvency law. Welcome all, and thank you so much for being with us today. Ian, we're in a period where lockdown restrictions are being relaxed, and a number of businesses have either already opened up or are expected to open up imminently. There is huge uncertainty, however, on how long it might take for business income to revert to 2019 levels. It seems most businesses are focusing on what they can control, managing their costs, and ensuring they have sufficient liquidity to absorb what are hopefully short-term trading losses. Ian, what else should business owners and company directors be thinking about as we come out of lockdown?
Thank you, Aleem. It's clearly a very difficult time for businesses. As you say, lockdown has now been 3 months and we're just starting to come out. And perhaps it was easier to go into lockdown than it is going to be coming out of lockdown. There's been a lot of government support. There's been the furlough scheme, so you haven't had to pay for wages. There have been help with rates. You've not had to pay those, especially in the hospitality sector. There's been the CBILS loans, the bounce back loans, and then there's been VAT and PAYE deferral. So with all of that, it's quite possible to mothball a company. But when you're coming out of lockdown and you're having to get teams back off furlough, you're having to pay rates, probably pay rent again, it's going to be very difficult to get the numbers to balance. Obviously, by taking on loans for bank loans and kicking the VAT bills and the PAYE down the road, that's building your debt, and your balance sheet is probably starting to look a little bit heavy on the liability side. We don't know at the moment how long it's going to take, as you say, for businesses, particularly hoteliers and retail sector, to know how long it's going to take to get back to even approaching 2019 levels. Do we know what a break-even turnover is anymore? Life's a little bit different. So trying to do those calculations, a lot of uncertainty. And I would say managing cash flow now is absolutely key as we come out of lockdown. So as you said, what can we do? Well, I would say you should always be trying to get advice early. No one is immune to COVID-19. There are very few businesses that will see no effect. So I would say doing nothing is probably not the right thing to do, just assuming that everything is going to be okay, because you're not the only one in these problems, and everyone is going to be looking to advice, trying to understand their cash flows, trying to understand their break-even levels. There are plenty of tools available to an insolvency practitioner. Some of those are very much debtor-based, such as the new moratorium, but particularly I won't go into that because it's not even law yet, but it's going to come in a few weeks' time. But particularly the company voluntary arrangement, we're going to speak a little bit about later. That allows companies, the directors, to stay in control and manage their business while a proposal with creditors is agreed. If you can't deal with it through a CVA, there are other options like an administration. That's a rescue process. I'm hoping to rescue the company, but if not, certainly the business, if that's successful. And obviously, if we really don't have a viable business going forward, then there's always the option of liquidation. Now, that's not a great option, it's a last resort. But as a business owner and as a director of a business, it's very important that you mitigate your own personal risk. When a company is insolvent, and you've got to understand insolvency isn't just about balance sheet, it's not just about whether your assets cover your liabilities, it's about whether you can meet your debts as they fall due, the sort of cash flow insolvency test. Now, a lot of businesses at the moment may well be solvent from a cash flow point of view, may be struggling on the balance sheet test, and soon as they come back and some of these loans fall due, they'll suddenly become cash flow insolvent. So that's going to create more and more of a problem. It's always cash flow insolvency that brings insolvency to a head. And that's really what we need to avoid. Administration is a process that can help with a rescue. And if not, then you're obviously back to liquidation. But all of those formal insolvency processes, what they do is they mitigate the risk of a director facing personal liability. If they continue to trade, and we'll talk about this later, or they're misfeasant in the way they deal with their creditors. Remember, if you are insolvent or about to become insolvent, as a director, you owe a duty of care to the creditors and not to the company and its shareholders anymore. So everything you should be doing is trying to make sure that your creditors aren't worse off as a result of your actions. So I would say use formal insolvency process where you have to, and if you can avoid it, then take advice and go down a restructuring, which could be a debt equity swap, refinancing, or as I say, a CVA.
Let me bring Ambuja in here. Ian mentioned a number of restructuring options. Ambuja, can you explain what are the differences between the various options and the pros and cons of each?
Yes, absolutely, Aleem. First one that I think I'll talk about is the company voluntary arrangement that Ian talked about, also known as a CVA. Whilst a formal insolvency process, it is probably the most light touch of the processes we'll be talking about today, in terms of interruption to a business, and in terms of external parties coming in and having a say about how a business is run. A company voluntary arrangement is in effect an agreement between a company and its creditors, and it involves the compromising, the restructuring, or the rescheduling of the debts that the company might have. An advantage of it, and I know that Richard's going to speak about this a little bit more, is that directors of a company can put forward in a CVA proposal whatever they feel is comfortable and viable and achievable for their business going forward. So directors stay in control, first of all, in terms of the proposals that they put forward, but directors also stay in control of the company itself, and the company will continue to trade through the CVA process. An insolvency practitioner will be the supervisor of the CVA, and whilst the proposals being proposed will be the nominee of the CVA proposal. The key thing about a CVA is that it will bind every single one of your trade creditors if the CVA is approved, and that's regardless of whether those creditors agreed to the CVA or not. So even if a small minority of your creditors don't agree with your proposal, the proposal will still be binding. Secured creditors such as debenture holders, classically, or banks or finance companies will be outside of the CVA, as will potentially employees in terms of preferential creditors. There is the possibility for a CVA proposal, whilst it's being prepared and put forward, for there to be a moratorium, so some protection for creditors whilst options are being considered. But I know Richard will talk about that later. And the other key thing to bear in mind with CVAs is that future and ongoing debts do have to continue to be paid as normal. The benefit of a CVA is that it crystallises a position and comes to a compromise in respect of historic debts, but future debts will normally continue to be paid as usual. In terms of how you enter into a CVA, shareholders obviously have to be party to it and have to agree to the CVA, but more importantly, 75% of your unsecured creditors have to agree to the terms that are proposed, and of that 75%, at least 50% has to be unconnected to the business. So that means any connected parties or any directors who might have lent money to the company aren't allowed to be taken into account when calculating the 50% approval level. There are obviously advantages of a CVA in terms of the potential exposure that directors of businesses have. So first of all, whilst it's a formal insolvency process, the insolvency practitioner doesn't have to do investigations in a formal way into a company that's subject to a CVA. So there's no report submitted to the insolvency service. This means that directors aren't at risk of being disqualified from acting as a director because the insolvency service don't get involved in the process. Again, putting a company into a CVA means that directors are less likely to face claims for any pre-CVA issues. But if there are any issues that the nominee thinks should be brought to light, those will have to be disclosed in the proposals. And again, Richard might touch on that a little bit more. The other thing potentially to bear in mind is that even if a company is in a CVA, if the CVA subsequently does fail, then there is potential risk to directors in terms of that. But you're managing the situation in a much better way as a director. And finally, the one thing that the CVA doesn't compromise is any personal guarantees that a director gives to any of its creditors. So anything that's an obligation of the company can be compromised by a CVA, but not anything which forms a personal guarantee that a director has given. But to be honest, that's the same as the situation in terms of personal guarantees in any of the other processes that I'm about to talk about. So administration was another option that Ian mentioned, and that's an insolvency process which allows for the reorganisation or rescue of a company, or alternatively for a realisation of its assets. Now, one of the key features of an administration is that directors will lose their powers to control the company. So an administrator will be making all the decisions about the company going forward. But the benefit of an administration is that there's an automatic statutory moratorium, which means that the company gets a bubble of protection from any creditor pressure and any creditor action. It in effect means that creditors aren't allowed to take any action against the company, to recover assets, to issue litigation against the company, to commence claims. Landlords are prevented from taking action as well. All of this means that the administrators have the ability to rescue the business and potentially sell the business as a going concern. And I know Ian, again, will talk about that aspect a little bit more. The process for putting a company into administration is relatively easy. Creditors don't have to be involved in the process, or at least unsecured creditors don't have to be involved in the process at all. Directors or shareholders of the company, or potentially a qualifying floating charge holder, which would be a bank or a financier with a debenture of a particular sort, simply have to file forms in court. And the filing of the forms itself in a particular order will bring about an administration. Alternatively, you can have an application to court made for an administration with a full-blown hearing, but again, that's not necessarily a complex process and can be achieved quite quickly. In terms of the impact on directors' personal exposure, an administrator will have to do an investigation into the company and how it was being operated and run in the lead up to administration, and the administrator will have to submit a report to the insolvency service. That's something which can't be avoided. The Insolvency Act also brings about a number of different actions which could be brought against an administrator, against a director by an administrator. So things that might be looked at would be issues of fraudulent or wrongful trading. In terms of wrongful trading, again, we'll speak about afterwards that there are some provisions being introduced potentially by the latest government legislation to protect directors to a certain form. You might have antecedent transactions, so if in the lead up to insolvency things might have been sold at an undervalue, or if certain creditors were preferred in respect of their debts rather than other creditors, directors could find that they find themselves in trouble for that type of thing. Or if there's anything else which looks like a transaction that's defrauding creditors, or if directors personally have induced a breach of trust. Any liability will normally be linked to the date of formal insolvency, and that's one of the key reasons why directors need to take advice and take action efficiently, because once formal insolvency has commenced, it will crystallize any action that could be taken against a director and therefore limit their exposure. And as I mentioned before, unfortunately, personal guarantees will remain, and there's nothing really that a director can do about that other than to negotiate and make sure that they can limit exposure to the creditor's claims generally. Liquidation, again, Ian talked about liquidation. Unfortunately, I would have to say is more akin to a burial of a company. It's a formal process, but in effect, the assets of the company will be sold, and then the proceeds distributed to creditors. There's not much else that will be done. The directors will lose their powers. The liquidator will make all the decisions: who to sell the assets to, what to do with the assets, how much for, etc. The company will cease to trade, contracts will be terminated, employees will be made redundant. It is the death of a company, unfortunately. The process of putting a company into liquidation, again, is relatively straightforward, relatively easy. The directors would have to work with an insolvency practitioner to prepare the paperwork, but it's as simple as shareholders' resolutions being passed and the approval of unsecured creditors using a process called deemed consent, which actually works quite easily, and it's quite hard for creditors to object to a liquidation process, although of course it is possible for them to object to it. Again, in terms of directors' personal exposure, everything that I talked about in administrations continues to apply in a liquidation, but there are a few additional things for directors of liquidated companies to be concerned about. One is misfeasance. Misfeasance classically will only apply in a liquidation scenario. It's much harder for it to apply in an administration scenario against directors. And misfeasance relates to a breach of directors' duties by a director in question. Ian talked about the fact that when a company is approaching insolvency, or if liquidation can't be avoided, directors of a company have to refocus their energies to protecting creditors' interests rather than acting and promoting the success of the business for shareholders. So misfeasance would be a breach of those fiduciary duties. The other thing, which is an additional, which applies to liquidations, is payments out of capital. And that will sometimes be a situation where in the year previous to liquidation, if there's been an informal restructuring of the business, potentially shares have been bought out of using company capital, that could be something that directors are asked to recompense the company for. So that's something to watch out for as well. But again, as with administration, if there is no option but to put a company into liquidation, the benefit is that the limit of liability is linked to that date of formal insolvency, and so directors can put an end to their future liability and exposure to that extent. And I think everyone can see the slide that we've got up at the moment. I do have on that a column that says do nothing for reasons which will be explored during the course of this talk. I don't think that's necessarily a good idea. doing nothing is exactly what it says on the tin, ignoring the situation, taking no action, burying your head in the sand, continuing to trade or attempt to trade the company whilst not taking professional advice. It means that directors continue to expose themselves to unlimited liability, and that continues and goes on for as long as the company keeps on trading. Which means that when eventually things come to a head, directors will expose themselves to each of those other issues that I've talked about, so the wrongful trading, the fraudulent trading, antecedent claims, misfeasance action, all of those things. You're kicking the can down the line, but you're not getting rid of the problem. And that's why.
Let me challenge you on something here. So we've obviously had a major shock in the virus and the government-induced lockdown. It seems the government policy is all about helping companies trade through this difficult period with the bounce back loans, the furlough scheme that Ian talked about. And I believe the government has introduced something where they've suspended the wrongful trading provisions. So does that mean directors don't need to be concerned?
So the government are continuing to introduce protective measures. The wrongful trading suspension that you're talking about is currently being debated. It's actually being debated in the House of Commons as we're speaking right now. So it's not yet law, but we anticipate that it will be law. And when it becomes law, we anticipate that from the 1st of March 2020 to the 30th of September 2020, directors won't be found liable for any financial losses suffered by a company whilst it continued to trade from that period, from the 1st of March to the 30th of September. That's a very limited angle of the types of claims that directors could be exposed to, unfortunately. So wrongful trading is when you continue to trade a company whilst insolvent. The suspension of wrongful trading for that limited period is simply saying to a director, I'm not going to criticize you if you didn't stop trading whilst COVID and the lockdown restrictions were impeding things. So it's a temporary measure. It's a little bit of protection. What it doesn't stop is requiring a director to be mindful of their fiduciary duties at all times. It doesn't give the directors an excuse not to act in line with their Companies Act duties to run a business properly, not to act under conflicts of interest, to promote the business, to act in the interest of creditors. All of that still applies. So I think wrongful trading suspensions could be helpful in certain circumstances, but in my experience, insolvency practitioners will look at wrongful trading as a last resort claim that they'll bring against a director, and they're much more likely to pursue antecedent transaction claims or misfeasance claims before they start looking at wrongful trading claims. So I don't want directors to have sort of a false sense of security because of these provisions, and obviously, as we say, we expect them to become law, but it's not actually law at this point in time.
Can you explain what do you mean by misfeasance?
So misfeasance is acting in breach of your fiduciary duties. So in the Companies Act, which is obviously the act which governs how companies are run, there are 6 or 7 key duties that directors have to operate by. So first of all, every director owes a duty to act within their powers. They have to act to promote the success of a company. They have to exercise independent judgment. They have to act with reasonable care, skill, and diligence. They have to avoid conflicts of interest. They have to declare if there's any personal gifts or benefits that they're getting. And they have to declare any other situations where they might have a personal interest. And that's all set out in the Companies Act, which gives guidance as to how a company director should act. A breach of any of those duties is misfeasance. So it's when a director acts wrongfully and doesn't follow those duties. And the additional duty that comes on board, apart from the ones that I've mentioned, is that once the company is approaching insolvency, the duty to promote the success of the business for the benefit of shareholders changes, and the directors have a duty instead to protect the creditor's position. So they
So
shouldn't be worsening the creditors' position.
let's take an example, Ambuja. So imagine you're a retailer and your shop has been closed for a while. And we know that a number of retail tenants haven't paid rent. I think only 50% of the rent roll was collected in March. It's expected that it'll be significantly less in the June rent roll. Some of the staff are on furlough, other staff are being paid, and suppliers are being paid. So as a director of such a company, could you be in trouble?
So arguably what directors should be doing is when a company is in financial distress, they should be treating all unsecured creditors equally and evenly. So we use a concept of something called pari passu, where you pay everyone in the same percentages. Now, taking that into account, there are obviously some payments which are key, and without those payments being made, you might find that the business evaporates completely. So if there's a longer term picture or plan for directors where they find that expending some money on a certain element now will help them continue to trade and potentially trade out of insolvency, that could be a good spend. But to simply choose not to pay a creditor because they're not shouting as loudly, or because their rights are hampered because they're not allowed to take eviction action and things like that, wouldn't be seen to be reasonable behavior necessarily. A lot of it, and I'm sure that Richard and Ian will talk about this, from my point of view, a lot of this is about directors communicating and continually assessing what's right for their business and having the conversations with their key stakeholders. If you can get your landlords on board and explain to them what your plan is and what you're looking at doing, that will obviously then help you make the decisions as a director as to how best to take things forward. But yes, if you're using the examples you're giving, if you've got a limited pot of money and, for example, you're choosing to pay your supplier who's your brother-in-law, that's much more likely to be not only a conflict of interest or a vested interest, but something which isn't a reasonable act for a director when you owe lots and lots of other people money as well.